Welcome everybody to this month's Caveon webinar series, where I'm very pleased to introduce two special guests. First, we have Ken Horton, who is an intellectual property strategist for the Gore Business School at Westminster University here in Salt Lake City. And Ken's going to be joined by Caveon's own Cary Straw. Cary may have more experience monitoring the internet for copyrighted material than anyone else on the planet, literally. He's been part of the Caveon Web Patrol team, a leader on the team for 9 years. So I'm going to turn things over to them very quickly. Really quick, some housekeeping. Everyone is on hold. Or I'm sorry, not on hold, on mute. But there is a question area in your GoToMeeting dashboard. Please pose questions as you'd like. We'll address them through the session or at the end. And then lastly, the slides will be made available. We're also recording the session, and the recording of today's webinar will be made available. So, with no further ado, let me turn things over to Cary Straw and Ken Horton. Cary?
Great, thanks, Steve. Next slide, please, Rochelle. So today on our agenda, what we'd like to do is kind of go over the scope of threats, relationship building skills that you can use in dealing with online infringement, the basis of copyright law and trademark law, and the steps to remove content, and then we'll wrap everything up. So first of all, good morning, everybody. We had such a great response to this webinar when we presented it last year. And the information is so important to your success when it comes to protecting your exams and your trademarks online that we wanted to present it again, but with additional information and some tools specific to trademark and logo infringement. So let's jump right into it. So some of you may know of a study by psychometrician Russell Smith that looked at the impact of brain dump sites on item exposure and item parameter drift. And during the study, an internet search of free brain dump sites found that about 25% of the item bank was exposed within only 3 weeks of the exam being published live, and with a fair amount of accuracy. After 8 months, nearly the entire exam bank, over 200 items, was posted with near perfect accuracy, including the answer key. And this is what happens when you don't protect your IP assets. Anyone can copy it, steal it, change it, sell it for profit. So what I quickly want to share today is how websites, more specifically brain dumps, are blatantly profiting from your unprotected exams. Next slide, please. So there's literally thousands of websites that purposefully steal your test questions and sell them for profit as test prep software packages, study guides, phone apps, etc. Which is a problem in itself, but it only gets worse because these websites are very incestuous. What I mean by that, next slide please, is that it takes just one brain dump to gain access to your test questions. However, within an extremely very short amount of time, those questions can be all over the internet, available to anyone, just by conducting a simple Google search. On this slide in front of us, this brain dump family tree, you see that one site, itsoulexpert.com, owns 62 other websites. And that was when we initially created this slide. And now it's increased by 3 or 4 additional sites. But they're selling the exact same list of test question packages. Now this site, as I said, keeps adding new sites to their family of test prep sites. And then they go to a different site, this exambible.com, which currently owns 25 sites. And there's dozens of blog archives that link and talk about to these main sites, including these sub-sites. So there's hundreds, perhaps thousands of sites that siphon off of these original brain dumps and steal the test questions from them to sell as their own. Next slide, please. So those are very intentional threats to your intellectual property. However, not all instances of copyright infringement are intentional. Next slide, there we go. Not all instances are intentional, but You still have a right, of course, to protect your authored content, even if the website doesn't plan or want to steal your exam material. So here's some examples of types of sites that may unintentionally have your actual exam material. Homework help sites, project and freelance sites where people will go out and offer projects and help to get things accomplished for you. Discussion forums, auction sites, eBay, Craigslist, things like that, as well as all the social media networks, Facebook, Twitter, Reddit, the list goes on and on. Now these sites themselves have the honest intention of trying to help students, test takers, but a homework or help project site such as Just Answer doesn't want to share stolen material. In fact, they make the registered user sign an agreement that what the user posts is not someone else's property, nor does it violate academic honor code, etc. Next slide, please. As a matter of fact, here's an excerpt from an actual terms of use agreement from one of those sites. Quote, you are not allowed to and agree not to use any of the solutions, answers, materials, or information available on or through the website, whether in whole or part, to cheat. Examples include submitting any textbook solution from the website as your own to any class, to any other violation of your instructor's or school's academic honor code. So as you can see, these sites are making efforts to curb infringements on their site, yet they still occur when members or employees of these sites, or members or employees of your own company, don't follow the rules. So what can you do? Next slide, please. First of all, create allies and work as a team. This is a team effort. So what that means is you need to build relationships with the people that are sharing your content. Now that's not always going to be the case. Sometimes you're just going to want to get things immediately taken down. But if this is a big problem or an ongoing problem, if you have forums that are used a lot by your students, these are great ways to help mitigate these problems. So first of all, start warm and friendly. Call first, make friends with the website, talk to who's ever in charge of it, talk to the forum administrator, talk to the site owners, make a friendly inroads at the beginning of the relationship. Now, once you do that, that can really open up a lot of doors because then these folks can help become your advocates. And once those relationships get to a certain level, they will actually help you remove content prior to it even being expanded onto the internet. A good example, we have a client that when we started with them, there were literally thousands of infringements every test administration period. Over the last couple of years in building these relationships, we literally have had our last administration that had 2 very minor infringements. They were taken care of within 15 minutes. That's powerful. And it shows the test takers who also know that they're being helped and watched, they help us find people to, or they help get this information taken down quickly. So these relationships really are powerful. Now, that doesn't always work. So the next step is send us a friendly bystander letter to reinforce the call if the initial contacts don't work. You can also then send a more formal cease and desist letter and reference the Digital Millennium Copyright Act, the DMCA, which Ken will talk about in more detail, if the friendly inroads don't tend to get the results that you're looking for. But, you know, build relationships with the forum owners, make them your friend. Now, you're not accusing these websites of copyright infringement. You're notifying them that one of their users violated their terms of use on their site. You don't want to get antagonistic or accusatory. Let the unintentional websites know that you're helping them avoid copyright infringement by notifying them that one of their users posted your intellectual property on their site. And above all, don't seek revenge. Stay professional. It'll only cause more harm if they get on the defensive. Now, Steve has a poll question for us, and then I'd like to turn the time over to Ken to give us some detail and insight on copyright and trademark law and how it protects you and your intellectual property. Steve?
Great stuff, Cary. Thanks. So, yeah, we've got our first poll. I'm going to launch it right now. And the question is, have you ever tried to build a relationship with a website operator or administrator in order to facilitate having compromised material removed or infringed material removed. So I can see that we've got people actively responding. We have about almost 3/4 of you have voted. We'll just keep it open for one more second. And almost 80% have responded. And I'll share the results. And it looks like the vast majority of folks up there have not yet begun to try to build those relationships, build those bridges with some of the websites where material may be inappropriately shared. So interesting. At this point, we will shut down the poll and we'll turn things over to our guest, Ken Horton.
Good morning, everybody, or good afternoon, depending where you are. Wanted to quickly go through, at a fairly high level, copyrights and even at a higher level, trademarks, to give you a sense of the landscape in this law. I want you to walk away from this webinar being fairly equipped to answer the following questions. What is a copyright? What materials can be protected by a copyright? What rights are granted? How do I get, maintain, and protect your copyright? And how do I enforce my rights? A big concern is always international considerations, and I know what that's going to be on everyone's mind. We're going to have that at the end, so just be aware that we are actually going to address that, but not till later in the discussion. Next slide, please. Copyrights actually protect an author's original expression of idea in a tangible medium of expression. Think of drawings, musical scores, sculpture, software code, almost anything that inventors can, or that individuals or groups can create. Next slide, please. The copyright laws have actually broken these categories of works down. There can be, these are actually called forth in the statute. It's broadly interpreted. It can include literary works, books, musical works, music, dramatic works, plays, pictures, graphs, sculptures, audiovisual works. They're not limited to those, but those are the most often categories of works that we often see, so the statute calls them out. Next slide, please. They also tend to group the kinds of copyrights in a loose arrangement. There's 4 of them. The first, which I will not mention, is just an original, something that someone creates on their own. Next is a compilation, which is a work formed by selection, assembly, and arrangement of pre-existing materials, facts, or data. Basically, someone is assembling all of this information together. Think of the Yellow Pages. All of that data is out there in the public domain. It's just how you assemble it all together. Next is a collective work, which is really basically you're assembling other collections existing together. Think of let's assume a book where each chapter is written by an individual author. Each individual author maintains their copyright within each chapter, but the selection and collection together can then be owned by someone who put those all together, the collective owner. And then the other one that's often used is a derivative work, which is where somebody takes an original work, twists it, creates their own on top of it, and creates what is a derivative work. For example, if I looked at the Monet, liked that, and I said, well, I'm going to paint my own picture of the Monet and my own interpretation of it, that's a derivative work because I used the original Monet as the basis on which I built my template. Next slide, please. The copyright, though, only exists in original works of authorship. It has to be original. That is very liberally interpreted. It can even be identical if you've never seen the original work. For example, if I had never seen the Monet, okay, that's a stretch, but if I'd never seen it and I went out and painted my own expression, my own original creation of the Monet, then that is basically an original work. It doesn't have to have any literary or artistic value or quality. It just has to be original. Next slide, please. What is not protected are things which are often protected through other forms of intellectual property. For example, symbols, designs, ornamentations, things that you can generally protect by trademark. We'll talk about that a little bit later. It's not protected as ideas and procedures, things you generally patent. We will not talk about that at all today. As well, facts and data cannot be protected by copyright. Now, the manner in which you express those facts or data can be protected. So if I have data that I decide to compile and put in the form of a graph, how I show that in the graph, what colors I use, how far my bar lines are, is it a 2D versus 3D, that's how I express it is protectable. But that does not mean somebody cannot take the same facts and or data and present them in a different way and not violate my copyright, because my copyright only exists in how I express those things. Next slide, please. The length of the copyright is, just remember, life of the author plus 70 years. When you're looking at this, if you're looking at a copyright, most instances, you're probably not, in our industry, not going to be reaching anywhere near the extension of that life plus 70 years. Tests change, knowledge changes. But if you are in the instance of looking at the very end of the term of a copyright, near that end of that 70 years, look at a time that term starts when it was created or published, and the laws were changed in early 1978. So if you're getting to that, I would just stop, go ahead and consult an attorney. I practice during the day as a copyright attorney, so I answer these questions all the time. But do those, but in most instances, just remember life plus 70 years. Next slide, please. What is granted? It depends on this category of work, if you remember. But you have the right to reproduce it or prevent reproducing it, right to distribute or prevent redistribution, performance, display. If you strip away that, if in layman's terms, it looks like I have the right to either make a copy or prevent from somebody making a copy, depending on how that work is presented. If it's a play, I have the right to prevent from somebody else from performing it. If it is a song, I have the right to prevent others from reproducing it or distributing it. Next slide, please. There are some limitations on copyrights, and these are often fairly important. A lot of people, you've heard the term fair use. A fair use is for criticism, for news reporting, teaching, scholarship, research. It cannot be a a commercial use. And the courts here are very, very cognizant of the fact of they're trying to weigh two things in their mind. One is this fair use is often similar to your right of freedom of expression. I want to be able to express my ideas. You're weighing that against the copyright, a commercial use. If you look at the top two, criticism and news reporting, those will almost always be a fair use, because in those instances, what are they doing? You are criticizing or reporting on something else somebody said. So if I just watched the NFL game and I want to report on the NFL game, I kind of have to show the touchdown, which is technically a violation of the copyright laws, and able to say, hey, that was a great catch. Or criticism, I have to almost quote the original person to say, I think that guy's an idiot. Now, if I don't quote him exactly the way it is, which is a violation of copyright laws, it's kind of lost on how I'm criticizing. The teaching, scholarship, and research have to be very careful, because while those could be a fair use, they also can be a commercial use, because a lot of institutions, even using those, could run afoul of, this is a commercial use, I'm making a profit. A lot of the times, judges will sometimes look at, are you making a profit out of this, or are you not? Are you trying to use it commercially, or are you trying to really do your freedom of expression? Next slide, please. Ownership. Who owns the copyright? Generally, the initial copyright vests in the creator-author. If I go out and make a song, it automatically is created in me. I automatically own it. Now, I can assign that, I can give it away, or somebody else can buy that from me. You have to be careful of a difference between an owner versus a possessor. Now, if I go out, if I create a song and put it on a CD and sell the CD, I still own the copyrights in the songs on that CD. The person who bought it from me, even though he possesses the CD, does not possess the copyright in the song itself. He has certain rights by purchasing that physical CD, but he does not own the copyright. A lot of people think, well, I have the right to make a backup copy. That is technically a violation of the copyright laws. Now, that does not mean that when you buy the CD or the DVD, that under the terms of the purchase, I, the copyright owner, can give you a one-time freedom of the copyright laws to make a backup copy, and that's at my discretion. But that does not give the possessor of that CD rights in the copyright to make 5, 10, 20 copies. Next slide, please. There are instances where, especially in these days, where they have what we call joint works, where joint works are created by 2 or more people, each having taken part in the creation of it. Each of them own an undivided interest in the work. They jointly own it. It's called in the law, it's called the joint tenancy. They own it together. Now, each of them can do certain things if they'd like without the permission of the other. If you find yourself in an instance where there's a joint work, you kind of have to be careful, because not all of the heads are always going to agree. Once it's created, they usually all agree. It's 1, 2, 3 years down the road that they often don't agree. Good case is a band that's very popular, Matchbox 20, let's use them. Rob Thomas all of a sudden said, well, I'm the lead singer. I own part of this copyright. Maybe I should go out and try to do what I can on my own. That comes into a fight because each of them owned it individually, unless they've taken steps to make sure that the band owns it as an entity rather than the individuals themselves. The other instance to be very careful of is what's called a work made for hire. Generally, if I go to Steve and ask Steve to create me a website, and said, Steve, I'd like you to create me a knock dead website for me. Now, who owns the copyright? I pay Steve, but the twist is here, Steve is actually the creator. Unless I tell Steve specifically how to create it, and I tell him the whole creation process, Steve is the one that created it. Since he created it, he owns the copyright in that, not me. Early on in the internet, a lot of website developers would develop them, take the money, and then turn around and say, okay, thank you very much. I own the copyright now. If you'd like to use this, you owe me an ongoing royalty, which a lot of the people paying for it did not like. So oftentimes you'll see this work made for hire. If you use that language in any kind of contract, that automatically means that the copyright vests back in the person who is paying for it. So in this instance, if I told Steve, please create me a website, and by the way, this is a work made for hire, that language makes that revert back to me, the copyright. You will see this language a lot in employment agreements, because an employee technically owns the copyright unless he's agreed that this is a work made for hire, which means it goes back and automatically vests in the employer. Next slide, please. How you acquire copyrights. Very simple. You acquire them when creating them. The law just says you own these when you create them. You do not have to publish them. You do not have to register them. We'll talk about those steps, but they can be advantageous to take those steps, and we'll talk about why. Next slide, please. Publication is when you put a notice of publication on the work that you have created. So if you have a song and you're out there selling it, you basically put a notice on that this is my copyrighted work. This used to be required, but no longer for obtaining federal copyright protection. There can be advantages, which we'll talk about as we go through here. Next slide, please. The notice of publication is fairly straightforward. As I said, it's optional. It's very easy in this digital era. Every time you create a document, to throw this notice of copyright, the publication notice on, very simply every time. When you're creating packaging, when you're creating your test, it's very simple to throw it on there, so it's very easy for the public to see that this is your copyrighted work. It has 3 elements: a symbol domain copyright, the year the work was first published, and the name of the copyright owner. So here it's copyright symbol 2014 Ken Horton. That way, people are put on notice that this is your copyrighted work, and we'll say why, which is advantage later. But it is so simple to do. You put it on packaging, you put it on everything else, just drop it in there. Next slide, thank you. The registration process, again, this is also optional, but can be very powerful. The statutory advantages of registering your copyright is that, one, you are presumed the owner. You don't have to prove that you are the owner any longer, and you can get statutory damages if you ever have to litigate. Most of these advantages are when you actually have to go out and litigate your copyrights. It is also a prerequisite to filing suit against an alleged infringer in U.S. courts. If you don't have a registered copyright, you cannot sue someone under federal laws. My recommendation, especially in the industry that everybody works in here with tests and having them copied, that always put your notice of publication on, and within 3 months, go ahead and file it and get a registration for every test. Next slide, please. The way to register it is pretty straightforward. You file the application, which is usually a 1- or 2-page form. You deposit it with the U.S. Copyright Office and pay a fee. The examination, when they look at it, only considers originality, is there fixed in the tangible medium, and is it the proper subject matter? That's it. It's almost like it's not to the degree, but checking boxes for the copyright examiner, and they send you back the registration. Very simple, very easy, very painless. So my recommendation is, if you have the resources, it's always a good idea, because if you ever wind up in court, it can be extremely helpful. Next slide, please. So let's talk about, if you have to wind up in a court of law, what do you have to do to really prove that that someone's violating your copyrights? There's 2 elements. One is that you have to establish ownership. If we registered our copyright, we are automatically presumed the owner. We don't have to prove that we are the owner. Then you have to actually show that somebody copied it. There used to be, it was kind of difficult to really show that there was a copying, so the courts got into an indirect versus direct proof of copying. In most days now in the digital era, it's a direct copy. We create a test, it has 30 questions, it's out on the website, it's a virtual duplicate, there's no question that it was copied. But this indirect copying can come into the instance of, let's assume there's a test out there, same 30 questions, they've just renumbered everything, but all the same questions are there. Is that copy? Often the question is this substantially similar to what we had? The courts, when this indirect proof, they look at 2 ends of the spectrum. They look at how much access you had to it, and then how much substantial similarity you had. The more access you had to a work, the less it had to be substantially similar. The more substantial similarity it is, the less likelihood that you had to show any kind of access. A good example is, let's use our test question with these 30 questions, where they have basically just renumbered all the questions. Is this substantially similar? I think most people would say, well, yeah, all they've done is renumbered them and rearranged them. They're still the exact same questions, exact same answers. They haven't deviated at all. Here, it's almost very, very substantially similar. They don't have to prove any kind of or we would not have to prove any kind of access to our original test. As I said, it's a nice thing to be aware of, but in this digital era and in what we're doing, almost all the tests are a virtual identical copy. So it's pretty simple. It comes down to, are you the owner, and is there a copy? That's straight. That's about all there is. Next slide, please. If you are successful in proving that they have infringed it, the question, what can you get? What are your remedies? One is injunctions from them doing it again. That's wonderful, but limited use if you've got someone that's a copycatter and they'll just open up a new website every single time. You can get the copies impounded, which is nice if you're not really in the digital era. If you've got somebody selling DVDs and CDs on the streets of New York, you can impound those copies. In our industry, a little difficult. Money is always great. Often you have to show, in any kind of litigation, you often to show, how have I been harmed? What are my actual damages? You can show that, or you could show these statutory damages. This is the benefit of registration, where the statutory damages does not matter how much you've been harmed. It only matters that the court, at their discretion, can award anywhere from $750 to $30,000 per act of infringement. This is used by the court to kind of look at how much good faith versus bad faith on the infringer side. So if this is an infringer that just slipped up once or twice, the court might say, well, yeah, you technically violated it, but you didn't aware of it. I'm not really going to assess you huge amounts. On the other hand, if this is a repeat offender who you've had problems with time and time again, the judge really just says, these people are just slimy. We know what they're like. I'm going to hit you with a full amount, $30,000 of each infringing act. And that's each time they post it on a different website. So if you look at that, if the same entity runs 10 different websites and they're posting it every single time, we're talking $300,000, and that's a pretty significant hit. Now, this increased damages. if we can show that they willfully knew about copyright and ignored our rights anyway, and were posting it and they infringed it, basically willful, you can triple those damages. So let's return to our example of the sleazy infringer who posted our test 10 different times on 10 different websites. The court really didn't like him and assessed him $30,000 per hit. You're up to $300,000. You can triple your damages. Up to triple damages, you're up to $900,000 for that individual. Sometimes judges are loath to do that, but it's always a nice tool, especially where they are basically thumbing their nose at your copyrights. Next slide, please. Criminal offenses, everything we've talked about are civil, where we are going against the other party. Criminal offenses are becoming more important with online piracy. Twist is you have to get the government involved, which sometimes can be very, very hard. The government will only tend to get involved if this is a fairly high-profile case and there's some kind of national rights or national relations being involved. Usually not the way to go to unless it's very, very, very rampant and it's somebody out of India or China and they're just doing it time and time again. The more important thing to think about is what's called indirect infringement. Direct infringement is when we have a user out there who is copying our test and putting it up on a website. Let's get an instance where the user is there's a user intentionally putting it up on Amazon's website. Amazon could be accused of indirect infringement. And to qualify for that, does Amazon have the right and the ability to control the infringer's acts? Yes, they do. They could lock the user out of their system and posting that test for sale on their website. Do they receive a financial benefit from the infringement? Sure. If the user on the Amazon website sells one of our tests, Amazon makes money. Knowledge is not necessary. Amazon does not have to know that this is copyrighted. This indirect infringement is what often keeps a lot of the Amazons, the eBays, very, very interested in working with us, because even though we don't want to pull them into court, they understand that we can, and they would like to avoid that at all costs. And we want to avoid that at all costs. But knowledge of this indirect infringement is what keeps them very interested in working with you. Not something I would really mention a lot to them, but if you're really getting in a tussle, it's a nice arrow in your quiver to kind of mention to them indirect infringement, kind of to make them pay attention that this is serious and they need to help you out. Next slide, please. DMCA, the Digital Millennium Copyright Act. What this does is prevent safe harbors for online content providers. If they do the following, they store the material at request of the user. So basically, this is for a lot of creative for the internet service providers. They're actually just caching data or serving as a flow-through. They are referring users to online locations where the material is located. They only store this material by system caching. In other words, they're kind of an intermediary, and they're only a conduit for the information. Now, there were some recent modifications proposed to the Digital Millennium Copyright Act to give more power to copyright owners. It did not pass in that time frame. I would not be surprised if it does not make another circle. Next slide, please. Now, to qualify to be this safe harbor, the internet service provider has to perform the following actions. They must adopt, implement, and inform subscribers or users of the policy of terminating infringement. They must accommodate and not interfere with the standard measures to identify and protect copyrighted works. They need not monitor or affirmatively seek out copyright infringement unless this is part of their standard technical measures, when they're working with a copyright owner to determine infringement. So they don't have to do any monitoring. The courts or the Congress thought that would be a little bit too much of a burden for them to do. They do not have to access, remove, or block the material if such action is prohibited by law. Now this gets into this flow back and forth. What happens in the Digital Millennium Copyright Act is that we, a copyright owner, see that a user has posted an infringing test on Amazon. Amazon can qualify for the safe harbor if they are actually just an intermediary or conduit, and basically they work with us through this takedown that we'll mention in a second. They work with us, both with us as a copyright owner and with the user who's posted the testing to determine, one, is this copyright? If so, let's pull it down. They basically constantly have to work as the intermediary or a conduit. So next slide, let's talk about what these takedown notices are. This is a notice where we see the test that someone has a copyrighted, infringed our copyright on a website of, let's say, Amazon or eBay. We often will send them a notice, and again, this is facilitated by Amazon or eBay, who have to help us in this process, because sometimes we don't know exactly who that user is and how to contact them, and that's why to qualify for the safe harbor, Amazon and eBay have to step in and help us. You have to identify the copyright, or if this is our actions, you have to identify the infringing material with sufficient detail. You have to give our contact sufficient contact information for us, certify that you are the copyright owner or agent, and then find and send notification to the service provider, here, Amazon, eBay, or whatever the service provider, who then has to pass that along to the infringer that is infringing our copyright. And then you go through this process of trying to mediate between the two to make sure that either one, it's not a copyrighted work, or if it is, to make sure it's removed. Next slide. This is, everything we've talked about is in the United States. But of course, as we know, the internet and the digital era has drastically changed. The geographical boundaries almost don't matter. Problem is, there is no global protection scheme. You cannot get a global copyright around the world. All protection you have is limited to a specific country. Everything we've talked about is in the U.S. Now, most other countries operate by similar, not the exact same laws. There can be some key differences, but most of everything talked about would probably apply in other countries. So your protection is limited. If you need a copyright, you have to secure it in the U.S., in Germany, in France, in China, in Hong Kong, et cetera, et cetera. Your enforcement is also limited in those countries. If I have a U.S. copyright, I can only enforce it in things in the U.S. Anything that's coming across or imported into our borders, made, manufactured, or imported, if it crosses the boundaries of the U.S., then I have the right to be able to do something of it with my U.S. copyright. But if you look at this, seeking protection and enforcing it becomes a matter of a cost versus benefit analysis. Because really, it's wonderful that I'd love to protect it in every country, but Jiminy Crickets, I don't have the money to pay lawyers in every single country and or to go to the courts in every single country. You often have to look at what are your major markets, what are your most important markets, and pursue protection in those. Generally, those markets are going to be, one, where do we operate? Two, where do we have the most sales? Three, where are our competitors operating? Because you want to have what we call jurisdiction over the competitors. So if your competitor's in Germany and you're in the U.S., you want to go to Germany, because if you have to sue them in Germany and you want a court action against them, the court has to be able to, take action against them. A U.S. court cannot take action against a German company, so you have to pursue it in Germany. And or where are your competitors' biggest sales? And then look at what resources, both in terms of manpower and in terms of money, that you have to throw at this, and then say, all right, these are our markets, or this is what we can do, and kind of draw a line somewhere and say, this is where we're going to finish. I'm sure there's going to have a lot of questions coming out of that. So I believe we have a poll now. Steve?
Yeah, thanks, Ken. Thanks so much for sharing such great content. Before I launch the poll, a question was just posed that I think is very relevant, and that is, this person is interested in how to get a copyright on a test. From the U.S. copyright website, it looks as though someone has to actually go to Washington to protect a secure test, since you don't want to upload it on the site. How does that work? How does someone navigate to actually get a copyright?
Okay. If what you have is go to copyright.gov. Most, they have a fairly good look for the FAQ section, which says, how do I get a copyright? There's a form that there's a filing, and it can kind of walk you through the process of filing and getting the copyright. Now, I know a lot of my clients who do this time and time again. They don't hire a lawyer every time, because they basically train someone in-house of, this is what the filing is, this is what they do, this is what I do with some of my clients. I help them through the process the first 5 or 10 times, work with the administrator. Then when they understand it, they pretty much say, okay, Ken, we get it. I think we can do most of the work. We'd still like you to review it before we file it. So you get the application, which is a couple pages, which you can actually fill out. You take it, you deposit, you send it, or you electronically file it with the Copyright Office, send it in the mail, send a check, and it's filed. Then it has that correspondence information in there, and then when the examiner picks it up and looks at it, they will contact you by mail if you put it in by mail, or electronically if you're set up in their system that way, and either say it's accepted or not accepted. If it's not accepted, they'll say why, give you an invitation to correct the deficiencies. Once it's corrected officially, they'll basically then send you the registration certificate. So it's pretty much, if you can't find that information, let me know, but it's a pretty good walking through of how somebody would do that themselves at the Copyright Office, but that is www.copyright.gov. And look for that fact section.
I want to keep moving, but another question arose as you were responding to that regarding the rules of Circular 64.
Not sure exactly what the rules of Circular 64 is. I'd have to, if you want, that could be a follow-up question. If that person wanted to contact you or contact me directly, that's probably something which, to take a quick look at it, we probably refer to it by a different name, not a rule of Circular 64, and I could just follow up offline.
Okay, great. Yeah, and so I want to launch a poll really quickly, and we've got a number of questions, so we want to get through the rest of the content, and then we'll open it up to Q&A. And so the last slide Ken shared regarded international infringement, and this question is, what percentage of your infringed content originates internationally? So I can see people are now beginning to respond, and we won't take long with this. We can just get a few more responses. I'm going to, okay, we've got 3/4 done. I'm now going to share this. We've got, most people aren't quite sure, but quite a few, about a third, indicate that as much as 1/4 of the infringed content they're aware of is on international sites. Reinforces what a real challenge that that is for test programs to deal with. So I'm going to hide this, and we're going to turn things back to Cary and then get into the Q&A soon.
So takeaways from the top. What?
Sorry, it was actually, it's supposed to go back to Ken. It's not up to Cary yet.
Oh, I'm sorry. My mistake. Back to you, Ken.
Okay. Takeaways from copyright. Your legal avenues are limited merely because of logistics and costs. Probably the best way to go is ask nicely first, ask nicely again. As long as they're being responsive and working with you, continue asking nicely. When possible, form a cooperative relationship, especially with companies who have an interest, who might be an indirect infringer, who have a vested interest in working with you. If not, and you can't do that, hit hard, hit fast. The difficulty with the copyrighted work is once it's like the cat in the bag. Once it's proverbially out of the bag, it is hard to stuff it back in because it just keeps getting proliferating throughout the internet. Okay, next slide, please. I want to quickly touch on trademarks. This is a very, very quick one just to give a high-level overview because I guess a lot of people indicated an interest in this. A trademark is a word, phrase, symbol, or design, or a combination of those, that identifies and distinguishes the source of the goods or services from one party from those of another. Case in point, I want Nike shoes, and I see the swoosh. That tells me it's a Nike shoe, not Adidas. The trademark itself must be distinctive. It must be able to identify the source and differentiate it from the good or service. Sometimes, basically, I cannot get a trademark for shoes because people are saying, well, am I buying shoes or am I buying the brand? They want to be able to recognize there is a brand that is a distinction from the product or service. That can be inherently distinctive just through the name. A lot of names are that way. Also, you can get distinctiveness through secondary meaning. This merely means distinctiveness through use. Your brand, even though maybe not distinctive, has gotten so strong that people recognize, oh, that's the brand, not just the product or service that I'm buying. Next slide. You acquire trademarks by actually using that trademark with a good or service in either sales or advertising. So if Ken wants to sell shoes, I sell Ken's shoes. As long as I start saying these are Ken's shoes, which is the Ken brand of shoes, then I start garnering trademark rights. No rights in the United States are granted by pursuing a registration, similar, not the same as a copyright registration, a little bit more complex, a little bit more money, unless accompanied with actual use. I actually have to use it because what it is people begin to recognize my trademark is used with a good or service. I cannot go out and compile a list of 100 trademarks and reserve them to myself unless I'm actually using them with a product or service. Trademark office will not let you do that. Your actual use, if you do not register it, can be limited geographically. Again, that was 10 or 20 years ago before the internet era. Now when you do sales and advertising, it's almost global wide. Next slide, please. Again, you have the right to prevent use of confusingly similar markets in the same mark. I often call it, you can prevent use of a substantially similar mark in a substantially similar market. Now, the product or service itself can be sold under a different mark. So, just trademarks, not copyrights. I can sell a test using the same test, using a different brand, but it's the exact same test. Now, we know that's a violation of copyright, but a trademark's that's fine because people understand that it is a different brand selling the exact same test. Or I can use a similar mark in a different product or service. Therefore, there can be a Delta Airlines and a Delta Faucet. People are not confused between the airline and the faucet. They're different markets, and so those marks, the exact same mark, can be used in different markets. The ability to enforce a trademark really comes down to this likelihood of confusion. Is there confusion in the marketplace? So if you have a brand and you're selling tests, and let's say our brand is, we'll use Caveon, and spelled with a C-A-V-E-O-N, and there is another company out there spelled Caveonite, just adding an I-T-E on the end of Caveon, question becomes, they're selling the exact same product. This question becomes, is that infringing? Is there likelihood of confusion? Because if someone wants to buy something from Caveon, would they see the Caveonite and be confused? If so, then there is trademark infringement. If not, there's no trademark infringement. Like with copyrights, with trademarks, the strongest rights are if you register them, not just use them. Of course, there are also international considerations, just like copyrights. Everything's limited geographically. Some foreign countries do not recognize use. They only recognize registration. So that can put a twist in the plan. Similar things with copyrights of bang for your buck in terms of what countries and what protection you want to look at. Same kind of thing with trademarks. I believe with that, I'm going to turn it back to a poll.
Yeah, and you know what? In the essence of time, because we've got some more slides and a lot of questions, I'm going to pass on the poll. So let's keep going to the next slide, please. And
great.
I think we're turning things back. Yeah, thanks.
Yep, great. Thanks, Steve. So first of all, I just wanted to apologize. I was informed that a few people weren't able to hear my remarks at the beginning of the presentation. So anything that you might have missed, we will have the entire presentation on our website in a few days, maybe sooner than that. So you can catch up on anything you might have missed. So first of all, thanks so much, Ken. Those were fantastic points. And what I kind of want to do now is touch on a little bit of trademark violation, but regarding misuse of your logo, company name, what you can do about it if you discover it, besides what Ken's already discussed. Next slide, please. So as far as misuse of trademark goes, this page shows the main page of a brain dump, uniquedumps.com. And if there's one, there's thousands. This one shows various company logos at the bottom of the page that are being used to imply that these companies are endorsing this brain dump and its theft and illegal distribution of their trademarks and other intellectual properties. When I'm pretty darn sure that, in fact, none of these companies would be happy to see this and may not even be aware that the site's using their logos. But by using these companies' logos, it legitimizes this brain dump site and their product without having to pay for or request the rights to use from them, from the individual corporations. And I think it's possible and probably fairly likely that some of you attending today may be on this list of sites, and I think I'm safe in assuming that you may not want the public to believe that you endorse this brain dump.
So that can be a huge misuse in the testing security industry or just in the typical trademark brand protection industry. Next slide, please. So if we kind of step back a bit and review again the options for getting your content removed, including logo or trademark violations, there are the same type of options to a certain degree that you have with typical copyright infringements. Now, one thing that you don't really have the option for with trademark that you do with copyright is the Digital Millennium Copyright Act. However, it does do an extremely good job when you do have a copyright infringement. I would say a huge number of things that we come across in our efforts are very positively responded to by sending out one, if not a few, DMCA letters. However, a takedown letter, a bystander letter, is also extremely powerful and works much more often than we've had to resort to Digital Millennium Copyright Act notifications. For your content that isn't copyrighted and for trademark violations, you can choose to send this informal notification. And while it's not legally recognized, it does, as I said, happen to be very effective. See first, once you send that, if you get compliance. If not, and you're certain it's a case of true copyright infringement, not just trademark violation, then a DMCA can always be sent as a follow-up. Next slide, please. However, these efforts on all fronts are very successful. This slide shows the top 10 infringing sites that we've come across in the last few years on all sorts of different arenas, test security, trademark, everything. Of the 846 threats found for this particular instance, 99% of those were eliminated. And some were eliminated instantly, some a few days, some a few weeks, some even a couple of months. It does take ongoing efforts for some of the more stubborn sites to take the content down. The point is 99% of that content is gone and no longer a threat to those clients. Most of that was done using bystander letters and, more importantly, building relationship with these websites. Now, where DMCA notifications can't help is internationally, and Ken mentioned those international concerns. What does work very well are the relationship building efforts and the bystander letters. Those work across lines of any country, and we've had very good success with all of those. Next slide, please. So we've gone over a lot of stuff here. So just to wrap up, what I'd like to give is just kind of a final thought. After identifying the breadth and depth of your content exposure, be it copyright, be it trademark, sending out an olive branch to the site and forum operators, sending out the appropriate takedown notifications, ultimately what the key is persistence. Persistence gets your infringed content removed quickly, and it helps to protect the security of your intellectual property from outside threats, and it goes further than almost anything else. And that can be the hardest thing for most companies, is just to keep at it. But if you do, the rewards are exponential. Thank you very much. We appreciate it.
All right, we've got a bunch of questions. Cary, thank you very much. We've got a bunch of questions and actually a number of comments, Ken. Apparently Circular 64 allows for the application of copyrights without sending sensitive test materials. And on the Q&A dashboard, we've provided the URL that people can use to learn more about applying through Circular 64. If we garner more information about that, we'll be sure to share it. So a number of questions. Ken, does the copyright of a test extend to individual test items?
Yes. If I create a test question and it is a single question and it's a half paragraph and A, B, C, D, copyright does extend to that. Now, when you consider that in terms of damages, in terms of what you can get for violation of just a single question, the courts will often look at how much, really how much impact has that one question had. So they often call it what's called a de minimis infringement, where if I have a question, if I created a test with 30 questions, and 29 of them are my original works, and one of them was accidentally copied from somewhere else that I asked someone to go get me one, and they didn't create it, they actually violated copyright and sent it to me, it's kind of sometimes viewed as a de minimis infringement. It is a violation, but in those kind of instances, the damages might be very minimal. But you can even copyright a sentence. Down to the sentences can be even copyrighted. Again, the damages are a question, but technically, yes, it's a violation.
So then a question was raised kind of the other side of that coin. So would you, is there a recommendation around copywriting specific exams, or I've got a huge item bank with lots of exams contained within it. Should I just copyright the bank? Is there a disadvantage to doing that? Is it better to focus on the specific exams within the bank? Or
yes, let's look at a different example. Maybe, well, this one's fine. But if you look at a CD, we all go out, the CD has 10 songs on it. We can either copyright the whole CD, or we can copyright each song. Each has its merits, or we can do both if you want to. Oftentimes, if you copyright the entire CD without copyrighting individual songs, leaves it open to some violation. If you copyright the individual songs without copywriting the whole CD as a collection, you run the risk of it. You might lose some protection. So what you really have to do, I think, is in terms of it, again, this bang for the buck. What is it that you think is likely going to be copied? If it is a series of questions, I'd copy those at once. If it's the entire test, I'd copy those. It's a bit of a guessing game when you have a whole lot of different tests and a whole lot of questions. And I am by far not an expert in the test security industry and in tests. So you really, ideally from a legal perspective, if you have a bank of questions, I would copyright every single question plus the bank. Problem is, I know that might be cost prohibitive, so you have to do a little bit of a guessing game. As you track it, as you put tests out, you kind of see which tests are most likely to be copied. Those are the ones that I'm going to definitely copyright first. Others, I might have to wait and see. So it's a bit of a guessing game, bit of a forecasting.
Great. Okay, thank you very much. So, folks, we are now up against the hour. We have a number of questions left. So, Ken, are you amenable to staying on the phone and answering some more questions?
Sure, that's fine.
Okay, thank you so much. So we strive to keep these under an hour, but when we've got good content like this, sometimes it bleeds over. So just as an extension of that last question, if you copyright the whole bank, or with the analogy you used, the whole CD, then wouldn't each song also be covered? And I think you said yes, they would be. Is that correct?
You can arrange it so that it is. When you file a copyright application, you often will say, I'm going to file a copyright on this and individual copyrights in each particular song. You just have to be careful how you do it and the way you go about it in terms of getting the copyrights in each specific individual asset within the collection.
So here's a question. A test has been in use for several years. Is it still feasible? Is it useful to have it copyrighted now?
Okay, yes, it is already copyrighted. The fact that you created it is already copyrighted. And we talked about you have some limited rights. I would enhance those rights immediately by putting a notice of publication, putting that copyright notice, the year you first used it, 2011, plus the owner's name. That gives you additional rights. And you can still actually register the copyright now, even though you've been using it for a while. Some individuals that come to me and they've created a song or something and they say, well, should I copyright it? I'm like, well, is it being used yet? If you've just created a song and there's no traction in the song, makes no sense to go spend the money on copywriting it for $500 to $1,000 unless you think you're going to recoup those costs initially. So I often tell them, well, that's great. When you start getting some traction, you start getting recognition, people start asking for it, or if you start seeing infringing copies pop up, that's when I would then go register with the copyright. So delaying filing the copyright registration, certainly permissible.
So thank you, Ken. Here's one more. We have old examinations and copyright documents. How long do we need to store them? If we want a clean house, should we scan and store electronic copies? Do we need to keep the original paper documents and copyright materials? Is there any direction you can lend along those?
I would say keep them. I would go scanning them is a good idea, creating them, but that scan is then going to show the date of creation. Is the file for a digital is going to show the date you scanned it, not the date that it was originally published. So while helpful for document retention, you still have to hold on to that original. I would create some kind of a simple filing system where you throw those original tests and those original documents, throw them in that file, keep them there, because those might wind up being useful down the road. Of course, the time to get rid of them is life of the author plus 70 years, so you might have to hang on to them for a long time. Now, I would change that if you think no one's ever going to use them, they are completely outdated, they are irrelevant, they are question tests from 30 years ago, which based on the subject matter, no one will ever use again. I'd get rid of them because there's most likely no one's ever going to infringe that copyright. No one's going to use those. There's nobody selling them, nobody's using them, nobody's copying them, so it's probably, and no one ever will, so it's useless for you just to hang on to the paper. So you have to make that first filtering process of, is this something which is still relevant in the market and might be copied and might be useful? If so, keep a hold on to it. If not, I might as a precaution scan it but then get rid of it, because in essence it's just clogging up the files. No one's ever going to use that test question, that test series again because of the subject matter.
So Ken, we've got more questions. I think to be sensitive to everyone's time constraints, what we should do is record these and provide some answers back in an email to the attendees so that we can just be sensitive to everybody's time. So I want to thank you very much, Professor Ken Horton, for sharing these important thoughts today. As always, Cary Straw, thank you for everything you bring with your wealth of experience in this area. And for everyone who attended, hope to see you at ATP. If not, we hope to see you next month when we share the important lessons learned. So again, thanks everyone and have a great day.
Thank you.
Take care.